Get this one. Come on.
Recording in progress.
All right. Good morning, everyone. To make that a little smaller, just temporarily while we go. This morning, we're going to deep dive into the GAR contracts for sellers under the settlement, as we like to say. We did, a few weeks ago, we did the buyer side. This week, we're going to do the sell side and look in detail at the changes to listing agreement, some of the additional forms and best practices and things. So first thing we're going to do is click on the right thing. So let's talk about what you have to do. This is like we did last time. What do you have to do under the settlement? Well, you still need to get a listing agreement signed, right? Like this one's a little bit easier because everybody gets listing agreements signed to work with sellers. It's not so much the case with buyers in the past, but with sellers, everybody gets a listing agreement signed. So that part's pretty straightforward. You need to specify compensation numbers. You have to put actual numbers in all the fields. You can't put other things. So make sure you put numbers in all of them. And then you cannot list them in the FMLS after August 17th or 16th. But in my realm, I don't see why you wouldn't start performing under these rules now versus later, right? Morning. It's a conversation that you kind of need to have. But let's look at a little video that I think some of you may have seen, we sent out. But let's hear from someone a little bit more legally minded than myself. Quick video, 3 minutes.
Hello, everybody. I'm Seth Weissman, and welcome to another episode of Safe Real Estate. Today, I want to talk about an important issue. A number of non-realtor MLSs have announced that they are going to continue to allow listing agents to advertise the commissions which are being offered to buyer agents on their MLS websites. And the question which every realtor has to ask is this something that I want to do as a realtor? My advice, and I know I am being cautious here, is not to advertise any commission information whatsoever on any MLS website, including on non-realtor owned multiple listing services. And here is why. We are living in very uncertain times. The Department of Justice is continuing to investigate realtor practices. The plaintiffs' lawyers are continuing to search for potential antitrust claims. And the one thing that both of those groups were trying to do was to prevent realtors from being able to search an MLS and steer buyers based on what commissions were being offered to the buyer agent. So I actually think there is some risk, albeit small, that if you advertise this type of information on an MLS, that it could result in some litigation being brought down the road. And my job as a lawyer for the last 30 years has been to protect realtors. I don't want to see any realtor getting sued for the practices that they are engaged in. And to me, it is a time to be cautious and conservative. And when you think about it, who would have thought a few years ago that the realtor community would have paid almost $1 billion to plaintiffs' lawyers for practices that everybody thought were perfectly legal and appropriate? GAR has created some very good forms allowing realtors and buyer agents in particular to protect their commissions. I think the smarter play is to use those forms and not to ever advertise commission information on a multiple listing service. I hope this episode of Safe Real Estate has been beneficial. As always,
All right, we don't need to listen to his pitch. Questions, comments about that?
I noticed that he still uses commission. I thought
He does.
Okay, but I thought we all had to switch to compensation.
I mean, it's the same thing. So
get it.
I
I'm
don't.
saying it's like certain things you can't say anymore.
Right, but I don't think that's really
Okay.
a hard and fast rule.
Okay.
I think they're trying to change the mentality of it by using the phrase compensation instead of commission.
Good
Morning. Just because they're trying to see if they can, get you thinking in the right direction. And it changes the mentality of the customer too, right? Like it's about compensation. I'm compensating you for the work you do, as opposed to a commission is a different mentality.
Commission's like not a choice.
Right, kind of, yeah,
Compensation's a little softer.
yeah, yeah. Any other comments on this? Yeah, please come up and talk into the computer here. And let's make everybody, we'll go big screen here, show some more people. Get all those people on.
Hey, good morning. How are y'all?
Move out the way so it'll pick you up.
Okay, am I on the screen there? I need a footstool or something, a high chair. Good morning, everyone. Okay, so when this first came out with FMLS saying they were gonna leave that in there, people asked me what was my opinion about it. I said I was very nervous about it. So I'm glad to see that Seth is, said something about this. And this will be our office policy, okay? So if you have any listings right now that have the compensation in there, it's time probably to take those out. Don't wait to the last minute to get those out of there on August the 16th, okay? You're not violating anything right now, having it in there, but August 16th will be our drop dead date. Now, I've asked Linda at the Oak Grove office after that date to start looking at our listings every day, just to be sure that we're staying compliant with that. What we don't need is a lawsuit on this. And so, I know everybody doesn't want one either. And so it'll just be a new way of doing business. And Brett will go through, the ways that we're gonna suggest for you to, help with the other side of this. So y'all got it? Thank you.
Is Linda, is this remove the commission?
Yes. Yeah.
So if we forget or.
If you forget, she'll catch it, yeah.
What about rentals? We don't have to worry about that. We can still offer well, I guess there was no buyer.
Yeah, it's not really buyer compensation there. I don't think that applies, because I don't think leases are incorporated, but same difference. And my opinion is FMLS, I believe that field is completely optional. So you can literally just leave it blank, which is what you see we saw on some people's listings when it first went optional, people forgot to fill it out and it was just blank. So blank doesn't mean zero, it just means blank, right? So I think that's kind of the way to go.
Zero.
No, I wouldn't put zero. I would put nothing.
I think at some point FMLS will probably take that field out of there.
I agree. I think it's just a matter of time before that happens. Probably. Whoops. Nope. Stop that. And we already watched that. All right. Let's look at the live forms here. We're gonna play a little bit of a game of. I feel like these forms are just too long to try and split up onto a bunch of screens. So we're going to look at the exclusive seller listing agreement. Everybody see that relatively well? That's pretty good. All right, so just like normal, we're going to deep dive into this form because we haven't yet in our series, our GAR series. And so we're gonna go in. All right, so pretty clear, this is an exclusive seller brokerage engagement agreement. 99% of the time, this is the one that you're going to want to use, right? This is the only one you can use if you're going to put it in FMLS. As you know, FMLS rules state that you have to be exclusive listing agent in order to list it in FMLS. So thing to consider there. The first section is all about the property, right? And so it's pretty easy. We put the address in. You put the tax parcel ID if you have it, which is good. And the legal description. This is where people get a little funny and don't always click the right things. But let's talk about the legal description. Does anybody have a preference on which box they use under legal description?
My preference is number two.
My
Box
preference.
two, box two is my preference.
Box two, I agree. Box two, I think is the easiest to fill out. Because 99% of the time, if you try to fill out box three, you're missing a bunch of things. And you might make mistake and it does weird things. And then box four is of course only for a condo. So if you're listing a condo, you kind of have to use box four, but you don't really necessarily, because if you use box two and that's a condo deed that you're referencing, then you're fine. So box two is my win. When you look at the tax records, there is a document field in Realist. If you look at the document field, it'll say document and it'll have a number dash number or number slash number. That's book and page. And you can always go into the county records and check those if you want to verify those. And then of course, if you want to use box one, you can always use GRECG, whatever, GSCCCA, a bunch of C's, which is the Superior Court Clerks of Georgia. And Linda can pull those for you if you want to get her to pull one for you. And then you can attach it as an exhibit, which is also a perfectly acceptable option. It's also not a bad thing to offer that as part of your disclosure package, right? If you can give the deed copy, the legal description copy with the disclosures, then that's good.
I have often asked the seller to provide recorded warranty deed.
Sure.
When they purchase, there's not an issue with that.
Yeah. Yeah, no, I mean, the only issue I find with that is that many people I know don't have it, right? Like they can't find it. They don't know where it is. So when you're asking them for that, that's just the first tip, that they don't have everything you need them to have. But yeah, so either of those I think is pretty good. Let's keep going. All right, list price and listing period. List price. I've seen few where you get somebody will list to be decided later, the whole commencement date and ending date of the agreement and the marketing date. Like, let's talk about all of those together. These are the next two sections. So one, in three, you need to list what multiple list services you're going to put it in. So you should always put FMLS and Georgia MLS, I think, personally. With the dates, so the commencement date is the date that this listing agreement goes into effect. So if I put today's date, this agreement is in effect today. The ending date, also pretty self-explanatory, is when this agreement ends. Marketing date is when I start marketing the property, right? So I don't have to start marketing the property today if the property is not ready, which is a common thing these days, right? We want the property to get in its best condition before we put it out there for the market to see. But it's smart to have a listing agreement in place sooner than later, because if somebody comes along and says, oh, hey, I see you're fixing up your house, we're interested in buying it, what happens to you if you don't have a listing agreement? You're not in that transaction anymore, right? And so the desire for people to buy things off market, the number of people out there, I mean, there are lots and lots of buyers out there that want properties. We still have a shortage of listings right now. So this does happen. So if you have a seller that you want to help, then you need to go ahead and get under contract with them with a listing agreement. Why is that in the seller's best interest? Because this is part of, to me, under the new settlement, we need to focus on the consumer. What are we doing that's, like, obviously that protects your commission, right? Okay, well, that's great, but is that the best thing for the seller? It is best for them to be represented because they, like you, are, if you went into a court of law and tried to represent yourself, which is perfectly legal and doable, it's probably not going to work out as well as if you have a professional attorney representing you. You know, I can stitch up my arm when I cut it, but it's probably not going to be quite as good as the guy or girl that has done that a lot and trained to do that and knows what they're doing, right? I would use duct tape, and I have used duct tape. But it's the same thing here, right? Like that seller thinks, oh, great, I can sell my property, save the commission, and everything will be fine. And it might be. But if it isn't, they're at the bottom of a well with no rope, right? And you're the person with the rope to help them. And so that's why I believe that it's in the best interest of all buyers and sellers to be represented by a professional. We had a we had a transaction going on right now with someone that is a for sale by owner, unfortunately, for them. And they have bought and sold a dozen houses. They own multiple properties. They portray themselves as real estate masterminds. And their biggest argument was, well, why did you wait to get an appraisal until after you went under contract? Why would we get an appraisal before we go under contract? Like, that's not right. And of course, their, appraisal came in, I don't know, 10% less than purchase price. And they're arguing that it's not valid and we should have gotten it earlier, and they're getting ready to kill the contract, and they're not going to get another buyer that's going to buy it for that, right? We know that appraisals aren't going to be that different. Like, I mean, that's a pretty significant difference. I mean, if it was a couple percent, maybe, but it's significant. And so now, you've got a seller that's not being properly represented. And I hope for their sake, the market continues where it is, because otherwise they're going to lose money and it's going to be worth even less than what it's worth today. All right. Any questions about dates?
I don't think so.
Nope. All right, good.
So can you put a price, to be determined price?
No,
Right.
price. I'm sorry. See, I skipped the price thing. Price has to have a number in it. Now, here's the thing. In the world where I'm protecting us and getting a listing agreement before we maybe finalize the marketing, we don't know, like, you're going to finish painting and whatever, and we don't know exactly how it's going to turn out. And so we're not really sure what the price is going to be. I don't care. Pick a number. Pick any number and put it in there. Okay. You need to have a real number in there, because if you write TBD, which is my least favorite thing to see on any contract form, because what does TBD do?
You don't have a valid rate.
It makes it invalid because it creates a hole. If you don't have all the terms of an agreement in the agreement, then it's not a valid agreement. Okay, so TBD is unacceptable in any field. You have to write something. So in this case, this is a dollar field. You have to write numbers. So write numbers. If you think it's going to be around $350,000, write $350,000. Before the marketing date happens, if that number is not the right number, what can you do? Amend it, right? It's easy, just change it. So it's not set in stone. As long as everybody agrees that you're going to change it to something else, then change it to something else later, okay? So don't be too hung up on the price, but you do have to put a number there, or else it's not a valid contract and you're not protecting anybody.
Hold on,
Uh-huh.
back to all the other forms, other things that need to be filled out. You can't put, you've got to have a start date and a.
Yeah, the dates all have to be real dates. Yeah.
To be determined.
Correct. No TBDs anywhere. And my recommendation is really leverage this box, the move this date up or back not more than blank days. That's one of those things that if you're paying attention to the situation, right? Like if they're doing a significant amount of work on the house, that probably needs to be a bigger number, right? Because you don't want to have to worry about, oh, well, it took the painter a week instead of 2 days, right? But if the house is basically ready, let's make that number a shorter number to help get everybody on the right track and stay forward. Again, these things can be modified. If you put a marketing date of whatever, 2 weeks from now, and 2 weeks from now, it's not ready, like they haven't gotten any of their stuff out, it's just not ready, you can modify it, right? Like you can amend it. You can either do an amendment or you can do the old school slash and strike. I like an amendment, but again, on this type of form, it's pretty straightforward to just put a new date in, not get rid of the old one. Marcy, kill me. Make sure you don't white out the old date. Just put another date down next to it, strike out the old one and initial and date. So that's the reason to use an amendment. So you're not making it ugly from that standpoint. All right. Did I miss anything else? All right. All right. Compensation.
About this, coming soon. Don't you have to have those dates in the computer to move to a coming soon if you're going to do a coming soon?
Yeah. So if your list, if theoretically FMLS rules are actually FMLS rules are that from the date of commencement of the agreement, you have to put it in the system within what, 48 hours, I think, or 72 hours, something like that. So, but there are statuses for that. So, come talk to us if you've got ones that you're doing early and we'll help you with that process.
Yeah, it's not coming soon. They have one before that.
They have a status before coming soon that's even, like if it's going to be more than a couple of weeks, there's a, God, I can't remember it now. It's called like,
Is it hold?
no, I don't think it's hold. It's something else, to be listed, or I don't know, but there is another status that allows you to put it further out. All right, let's talk about compensation. This is the biggest section of change in this agreement from the previous years and even this year's. The compensation. So compensation to the seller's broker. Seller agrees to pay seller's broker the following compensation at the closing of any contract to sell, as that term is herein defined, of the property as follows. So if you are going to charge 5 bananas because that's how much you want to get paid, okay, this is the key. This is how much you as an agent and our brokerage want to get paid. So this is your compensation. Now, this is where it gets a little quirky. In the old school one, you would put the total in the first field and then the amount you're going to share with the buyer's broker in the second field. That is still an option if you check seller's broker out of the compensation being paid in the second section here, this little box right here.
Which we don't.
Which we don't recommend. I recommend that you check the first box, which means the seller is going to pay the buyer's broker on behalf of the buyer directly. So that number now becomes in addition to the first number. So it's no longer 8 and 4 bananas. It's 4 and 4 bananas, if that makes sense. Again, I'm just using random numbers. It's all negotiable. You need to make sure you explain to people it's all negotiable, and make sure that they understand that. In the way the boxes are laid out, the first box is spelling it out like FOUR, and the second box is the number 4, or whatever number you are going to put in there, if that makes sense. So we highly recommend that you're going to check this first box on all of your agreements, because we think that it's important to separate what you're getting paid and what they're getting paid. Is everybody clear with that? Questions about that?
I have a question, Brett.
All right, ask away.
So I feel like in this situation, obviously, when you're doing a listing, you're having a conversation with the seller about how you're getting paid and how potentially the buyer's brokerage is getting paid. But is it also something that we can just leave blank?
No.
So we have to have that conversation right up front in the sense of it has to be like, what if they're like, I don't know if I want to pay, or I don't know if I want to pay an X%, or I mean, so we have to have it in contract that they're paying something towards the buyer's broker
Or zero.
or zero.
Right.
Because
So
I know, I
you
mean,
could
I'm
very
not a
easy
listing.
put in zero in there, and that's perfectly acceptable. But you do need to put numbers in here because you need to be very clear on what they are agreeing to do. If you were, for instance, to just fill out B and not fill out C and just leave it blank,
Yeah.
then that's a question of, okay, so what are you willing to pay, right? What are you willing to do? And that becomes a complication in the conversation. So the way I would approach it as a conversation is, let's talk about B. B is how much I get paid to do my job for you, right? As a listing agent, I get paid X amount. I collect X Mercedes in order to do my job for you as a seller. Okay. This is what I do for you. I negotiate on your behalf. I do all the marketing. I do all the things. This is my job for you. Okay. Now let's talk about C, which really falls under almost marketing of the property. It is relatively common practice in all markets in Georgia that I'm aware of that buyers brokers compensation is covered by a seller pretty commonly. So if you weren't offering compensation, what does that do? Which is your choice, right? Like as a seller, you can say, I don't want to offer compensation, but we know that depending on the price range, for example, if I have a buyer that is going VA, they're not putting a penny down, they don't have any cash, let's just assume. If they have representation and they go to look at your listing and you tell them that there's no buyer brokerage compensation coming from the seller, they might have to move on to a different listing because they can't afford to pay the broker on their side. And so you have to know, what does that mean, right? Is that going to scare people off? And so from my perspective, I still believe that all the compensation is a part of the actual purchase price. I have never in my career seen people take out a commission and keep the price where it was. Those two things usually adjust at the same rate. So if you're removing compensation, you're typically lowering the price. Like it all is the same, right? Appraisals take into account the fact that compensation is included in the price of all these homes that are sold, right? Like that's just part of the market. So I think that's the conversation you have to have with them, and you should have it up front. Now, just like everything else, they can say, you know what? I want to try it and not offer any compensation. Great. All right, let's put zero and move on. And then we don't offer any compensation. And just like every other decision they make in here, whether it's the price or, marketing efforts and things like that, we can make changes to those, right? So we can always come back and amend that. We've had examples where people have tried lower buyer brokerage compensation numbers, and it hasn't worked very well because I think buyers are a little hesitant to go in and not know if they're going to have to bring more cash to the table or not.
So under the scenario where under C, where the seller is offering zero. Just to be clear for everybody, if there's an offer and buyers request that the seller pays, they can still negotiate.
They can negotiate it in the contract.
Right, but I-
Correct.
Becomes a negotiation item.
I
Correct.
just wanted to make sure everybody. was-
Yeah.
You're just not upfront offering.
Right.
So it's kind of like, if you think of the old days, I remember doing like pre-home inspections, and getting inspections and offering those inspection reports, or knowing that I was gonna offer a home warranty because the house needed a few things and maybe it would be a good selling item to offer home warranty. So that's a cost to the seller that the seller has pre-decided, I think I should offer a home warranty because I think it'll entice people to want to buy the house, right? And it'll just make it more appealing. And so that's the same thing here. This section down here at the bottom where it says the if sellers offer compensation to the buyer's broker is conditional. My least favorite field in the whole form. That is the field where people say things like, if you don't show your own client, it's whatever smaller number and all that kind of stuff. I don't like those things.
Or a full price offer.
Or if it has to be a full price offer, which it could be. So that one actually seems a little bit more legitimate. Then, you know, and so they can make it conditional, right? They can say, all right, yes, as a seller, if I get a full price offer, I'm willing to pay 14 bananas or 8 bananas or whatever it is, right? And so that's fine. Then the separate commission compensation on lease is a section down here. If you're not going to charge a compensation on lease, you can put NA in there if leasing is not an option, right? Like if you're not trying to, you can put NA, which is not applicable, right? Because you're not going to lease the property. What about, and this is where this world comes into, what about the situation where you have an unrepresented buyer? If I put my number up here in B and the buyer broker side on C, well, if I have an unrepresented buyer, do I get to get some of that buyer's broker compensation? Right, because it's not part of you're not the buyer's broker, right? They're unrepresented. So I've had a couple conversations with people, and my best thought on that is in the special stip section, which is way down, we'll get to here shortly, is where I would add a stipulation that says, if the buyer is unrepresented, if, again, this is all negotiable, right? If an unrepresented buyer comes and you want to collect a higher fee because you are working harder, which I don't disagree with, I think is a valid thing, then you would need to put a special stipulation in that says, if there's an unrepresented buyer, the compensation to the seller's broker will be X, and it will be a different number than is in B. It's a spell out of a special scenario, right? And you have to put that in there. If you don't put that in there and you only leave 4 bananas up here in B, and you want to charge 8 bananas because you are having to do all the work, can you do that? Not without a written agreement that says that. So you either
And
have to.
that would be an other.
No, that's going to be a special stipulation,
Okay.
not in other. I wouldn't put it in other, just because other gets one, it's not very big box. And I would write it all out. So that's the key. You want to make sure it's written in the agreement that the numbers are different if there's an unrepresented buyer. Okay.
This is compensation to seller's broker.
Correct.
Not the optional compensation.
Correct. Not the optional compensation to the buyer's broker. This is the compensation to the seller's
Leaving the
broker.
buyer.
If there's no buyer's compensation, because then that's the other part of it, and we're getting around on some other forms, which we kind of have to, is if you have an unrepresented buyer, and we're not going to look at the form because I don't think we have to, but well, we might actually, we will. Let's try to jump to that in a minute. All right, so we'll talk about the customer acknowledgement form before we get done, because that's an important one. Protected period. This is the part that protects you. Okay, it doesn't protect you if they list with someone else, but this is the part that protects you. If they terminate your agreement or the agreement ends and they go to a buyer directly, that sort of thing, right? Agency and brokerage not,
Suggest how much time?
I always put 180 days. Almost always. Now, again, everything is situational, but I feel like 180 days is long enough to make sure that it's painful. Right? These are penalties. It's kind of like I didn't move out when I was supposed to on either a lease or a temporary occupancy. Like if that penalty is not severe enough, like if it's just something that I can manage, like, oh, it's $100 a day. All right, well, that's bad, but it's not as bad as me having to move all my stuff and whatever. But if it's $1,000 a day, oh shit, no, I'm gonna get out, right? Like that's the kind of thing to think about. All right, not offered by the brokerage. We don't do sub-agency as a brokerage. I would love if you would check not doing dual agency just because I don't like dual agency, but it is legal, so you don't have to check that. The lead-based paint disclosures, obviously, if the property was built prior to 1978 or in 1978, then you need to check that and attach as exhibit and label it, the lead-based paint disclosure, which gets attached to the listing agreement. Okay, that's an important little note, is that this listing agreement is incomplete. If you mark A and you put it as exhibit A or B or whatever, and it's not here because, oh, you're going to do the disclosures later, your listing agreement's incomplete. So that lead-based disclosure, paint disclosure, needs to be a part of this agreement, which means then you have it for everyone that is a potential buyer, right? Okay. Special circumstances, always ask. The beauty of this section is, hey, is there any special circumstances going on? You guys aren't getting a divorce or anything, right? And you can kind of play it off a little bit, but at the end of the day, this gives us the opportunity to ask that question, because, when you have a seller that you list their property and then they go into bankruptcy, it's not fun. If you have a seller that's going into a divorce situation and you don't know it going in, it's not fun because all of those things cause delays. All of those things keep you from being able to close properties for buyers, and people get upset. 9, it is possible for a seller to say they do not want you to negotiate on their behalf. Okay? That is the second option down there. I think that I would only work with people that check the first part, right? Because that's a big part of our job, is negotiating on their behalf. I mean, that's part of what we do. But again, technically they could say they do not authorize you to assist, which, is that. For today, I'm going to skip through because we don't have a ton of time, but I'm going to, maybe next time we'll come through and go through the details of all of these. As always, I highly recommend that you read all of the stuff. Protected period is an example. If you just put a number in there and you don't know what it means, are you really protected? Probably not, because you don't really know what you're protecting yourself with. And so the protected period is a piece that you need to understand that how it works. So we'll come back in a next session and we'll go into great detail on all of those. But I want to be able to get to the other forms under the settlement that we need to cover. And as we all know, I take a long time to get through some of those things, and we have lots of discussion about it. So we'll keep that for the next one. But let's jump to brochures. Brochures are your CYA.
Yeah.
Okay, they are your best friend. You should be giving these brochures to everybody. I would carry around the ABCs of agency with me in a way that every time I talk to anybody anywhere, I'm in the line at the grocery store and the person behind me starts asking me questions because I've got my name tag on and they're like, oh, you're in real estate. I see the balloon. tell me about what's going on, blah, 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 blah. Well, first of all, let me just give you this ABCs of agency so you understand who represents who, right? Because I think the ABCs of agency is one of the best things in the world to hand out, and you should give it to everybody. Like, I mean, when you have a party at your house, here's a parting gift, ABCs of agency, right? Like, let's just make sure everybody understands who represents who and how that works. Because people don't, right? Like, you think because you're in the real estate industry that people understand, but they don't. And so it's important for you to explain that to people up front. And I want to give it to them on a first possible meeting. So I probably have already given my sellers the ABCs of agency when I first started talking to them about listing their house. Well, okay, that means I'm going to check this little box because I want to make sure that we note that they got the ABCs of agency. The lead-based paint pamphlet. On a listing, is it important to give a lead-based paint pamphlet to every listing? You can, but technically only the ones built prior to 1978 really matter. But again, it's educational information, right? Same thing with the mold and the EPA, the protect yourself when selling real property, and what you should know about short sales and distressed properties. People forget that one or leave that one off a lot because, oh, well, my seller's not in a distress situation. Well, maybe they weren't when you listed, but maybe something happens, right? So educate them, give them the information, let them know what they're potentially looking at. These are excellent, not just CYAs, but educational pieces, right? We take for granted all the stuff that we know about real estate. A lot of the things in these pamphlets, you should be giving them to people. I would probably go so far as to give these to for sale by owners if I was working with them, right? Because they're just educational pieces. They're
You could add all that to
Yeah,
it.
you
If
just-
You send them home, we have a record that they have received it.
That's right. If you're in Dotloop, you add those to the transaction, it sends them to them. I don't think you send it with the signatures, but you send it as an email so they have them all and they can read them. Exhibits and addenda. So exhibits and addenda, obviously you've got the legal description, you got the lead-based paint exhibit, and you have the retainer fee, which we haven't talked about because we'll have to go look at that form. But this is where I would, in the special steps, write that stipulation if you're going to do something different when there's an unrepresented buyer. Okay. Not that I'm aware of. There's not a pre-written that I'm aware of. But pretty straightforward. You're just going to say, you know, if there's unrepresented buyer, there's no buyer's broker, however you want to phrase it. The seller's compensation to the seller's selling broker is X.
Obviously, you'd want to do that first, but say you forget or we'll talk about it later.
You can amend.
Right.
Yes.
Exactly.
So Ben's
right.
question is what if you forget to do that? And it comes up. Well, then you can always do an amendment. And so that's fine. But again, we try to get as much stuff done at signing as possible.
It's a good idea to talk in case you do.
Right.
While you're there discussing it, like, there is a chance that there's somebody that will come in without a buyer broker, and I will charge additional 1 or 2% or whatever.
But
So I'm just wondering, like, some people get skittish about extra things.
Sure.
Maybe you just go, you know what, if we cross that bridge, we can amend this. I just want to know that you can say,
You can.
I can say we can amend this if we don't.
Absolutely. And you should say we can amend this, like, as long as we agree. But see, that's the trick. Everybody has to agree to make an amendment. If you get everybody to agree while you're signing it, now everybody has agreed. Right.
I've agreed it's 3 bananas, not 6 bananas.
Right. And so it's, you know, it's the work.
Bananas, agreed.
So signature blocks on the listing agreement, very, very important that you fill out all of these blocks. Okay. Drives me insane when we get a signature with their typed name and nothing else on there. You need to have their email address. You need to have their phone number. You need to have their address, especially if it's not the address that's the house that you're listing, right? Because you want to make sure that we have a way to communicate with them should we need to communicate with them officially. So that's with the notices and things. Same thing for your stuff. All of this stuff needs to be filled in. And the most important box you need to fill in at the bottom that they get a copy of this. Okay? And so sometimes with e-sign stuff, it's a little bit hard to manage as to when it's going to be signed and things like that. But feel free to come back and fill in afterwards and say, okay, here's the, I sent them a copy at 5 o'clock on, whatever. Okay? Any last questions about the listing agreement before we quickly jump into the others? No? No, I don't want to save changes. Just goofing around. All right. So let's look at the form, this one, 258. I believe personally that you should, and this is our office brokerage best practices, is that you should, as a listing agent, get this form filled out when you do the listing agreement, if the seller has agreed to pay any of the optional buyer brokerage commission, if that makes sense. Okay. If they put 0 in there, really no point in doing this form because it's 0, right? And then you're just telling people the seller is not offering any compensation to the buyer's broker. But this, if you get this form filled out and you go ahead and put in there that the seller is, this is the compensation being offered to the buyer's broker, and that the above compensation is from the seller. Remember, this is in addition to, so you want to check that first box. I double look at it because I want to make sure I'm checking the right one, right? You guys should do the same thing. So it's that first box. And so you're just going to put the same number that's in C in the listing agreement, in 4C. All right, those two should match. Okay. And then you just have them at the bottom down here. You're going to fill in your information, sign it, and then they're going to sign it down here, saying that the seller is going to. And then I would print these out and put a stack of them in the listing. That way, when anybody shows the property, they know what the compensation offer is, and they have the document to support it, so they don't have to make it part of the contract. Okay? They can literally just sign this and send it back to you, and they're good to go, as without having to include it in the contract. So then that means that you can give this, or you can you would do a normal instructions to closing attorney to give to the closing attorney to show what the compensation is, because it's not in the contract.
So what if the buyer's agent sends that over with the offer? That form.
So they can send it with the offer, but hopefully they don't make it a part of the offer. Like that's the part that you don't necessarily want.
If they do, then what?
It's not an exhibit.
Then it's not, I mean, it's really not an exhibit. You could theoretically mark it as an exhibit and put it into the contract. I don't know why you would do that, but you could. But the reality is that, again, part of the settlement is transparency. So I don't really care if they do that. It's weird from my perspective, but everybody has seen this and is aware of it. And obviously the buyer's aware of it, or else they're paying out of their pot, right? Like they should know. And so everybody's aware of this, and it should just be part of the conversation. So for it to be part of the, it really shouldn't be included because it's not really part of the contract. But if you send it with it, which happens a lot, they do. They bundle all kinds of stuff, love letters and all that thing. It is a separate freestanding agreement.
Piece of paper that is its own.
Correct. Correct.
I have a question about the dates though.
Okay.
So at the top, there's a date. Do we put the date in when the seller signs this at the very beginning?
Yes.
And then what do we put in the date field where it says seller's broker within blank days of the above reference date, if you're just gonna put this in the property?
Correct. So if I get a 3-month listing or a 2-month listing or whatever, I'm going to put today's date up here at the top, because that's the date that we're executing this document. Now, the buyer's broker is gonna sign it later, but that's okay. And then I'm gonna put in there, X number of day, 60 days if I have a 2-month, listing
Whatever the
agreement.
end
What,
listing
basically, I'm gonna
is,
line those
whatever
up
the end
with the listing agreement, right? And then if I have to do an extension on a listing agreement, unfortunately, sometimes that is happening, then, you're gonna modify this. Or maybe you just do a new, right? Like, that's not that hard either.
Right, and then I have one other kind of weird question, but. Seller agrees to 3 bananas.
Yeah.
Okay, when we sign this, and we do this and we put it in the house. Seller then drops the price and says, with the price drop, I'm only doing 2 bananas now. So we amend our listing agreement.
Yep.
We would have the seller sign a new one of these. However, there are old ones of these floating out there that buyer's agents have picked up. What do? We don't know that they have them.
Yeah, that's true. The reality is that the newer dated one should theoretically replace. You could
We
write,
haven't revoked this as an offer.
you could say in the special stipulations that in all of them, you could say in the special stipulations that any newer dated versions of this agreement will eliminate this as being a valid agreement. You can, there's ways you can write that in there and basically negate the ones that used to be out there.
So let me just say, basically, we're saying seller reserves the right to change the commission amount at any future time.
Yeah.
Therefore, we on the buyer's agent side, pick one of these up, and it says that. We can't rely on this. We still need to put the stipulation in the offer contract, because this may or may not be valid and we would not know.
Well, that's where you need to talk to the listing agent, right? If you're on the buy
If
side.
they say yes, and then they say, oh, forgot to tell you, right? So again,
Yes,
put the stipulation, if we have one of these, still put the stipulation in the offer.
you could, and you absolutely can. Here's the drawback, whether you're on the sell side or the buy side, is that as soon as you put the compensation into the agreement, it becomes part of the negotiation. Now, it's always negotiable,
I'd rather get paid.
but by putting it in there, you are opening that up to something that the seller or the buyer, it's just becomes one of the terms that we're now negotiating.
But if buyer and seller if we have a buyer agency agreement at 3 bananas.
Yep.
And buyer says, hey, seller, I want you to pay 3 bananas in my offer. And then seller comes back and says, I'm only paying 2. We're still getting paid our.
You're still getting your
because our
3.
buyer's
That's
on
right.
Buyer and
Correct.
seller can negotiate all they want.
That's correct.
Contractually, we are still protected.
That is
So
correct.
that's the conversation
Yes.
to have with your buyer. If they try to negotiate, that is, you take it down to 0, then it's coming out of your pocket.
Correct. And then, so as long as you have a buyer brokerage and as long as you have a listing agreement, which is usually the easy one to have, not easier to get, but everybody gets them. And that's the key. You need to focus on protecting and getting paid what you want to get paid to do your job. What somebody else gets paid to do their job is not your responsibility. It's somebody else's. Now, do we think that offering a buyer brokerage commission compensation is beneficial, like we talked about earlier? I believe it is, but it's not, again, that's not your responsibility to make sure they get paid. Okay, that's part of the negotiation for each party with their own representation.
I know we've looked at a lot of forms, you and me and Marcy.
Yeah.
On the instructions to closing attorney, didn't that change if the seller signs that too? Do you have that to pull up?
Yep.
Only in the seller is.
If the seller is offering compensation. All right, so let's go to that.
Brett, can I ask you a quick question before you get off of that? Is that a document that you can upload with documents, like when you're
No.
no, okay.
Absolutely not. Because
Okay.
this shows what the compensation is, and if you upload it into the MLS, you're violating the settlement. So do not,
Gotcha.
do not, good question, thank you for bringing it up. Do not upload this form into any system tied to the MLS. That includes showing time, okay? If somebody schedules an appointment through showing time and you automatically send them this document, that's a violation of the settlement per all the lawyers, okay? So we don't want to do that. Where's my, I don't know, let's see if I can find it this way faster.
I think the shorter time frame is how I'm gonna handle it. So if there's an open house, 7 days, 14 days, something, the amount of time I think my seller is gonna wait until changing the price.
Yeah, you could also do it, 2 weeks at a time or 30 days at a time or whatever you think is reasonable. And then it's a little extra work and you burn a little extra paper, but that also is a way to manage that, right? That, hey, for the next 30 days, I'm willing to pay this much.
You also could say, seller, are you willing to guarantee that you will pay the buyer's broker within 4 days of the first time they show the property? So the seller could put a stick in here.
Yeah.
Saying this is only good for 4 days after the buyer's agent first shows the.
Yeah.
property.
Could, for sure.
It could be good longer, but it's up to the buyer's agent then to verify.
Yep.
And check.
Or
I'm worried about this on the listing side.
I hear you. And that's what we're talking about today is the list side, right? We want to make sure that we're protecting the seller from different situations that they might get into and us, right? And to make sure that we're, that's part of our job. This is the instruction to closing attorney form.
Brett, I have a question in a minute.
Yep.
So I have like 10 showings set up through showing time
Yep.
to see properties with the buyer. And I go into the message center there and I message all the agents and I say, what's the compensation? Hopefully they message me back. Is that okay?
So you're using the messaging inside showing time.
I'm using the
Yes.
messaging feature within showing time. Yeah. It's like
Yeah,
a
because
testing feature.
it's not like an automated, they're not posting it, you're not posting it. It's just a way that you're communicating with someone. I don't see why that would be an issue. But again, you're not sending the form that way on a list side.
Right. I picked that up. We're not sending the forms yet.
Right. But
So
it's not a big deal to ask or
Okay,
communicate
so-
to them through that. I mean,
Well-
personally, I would probably do it through text. Just because I think people are more likely to respond to that faster, although some agents, it varies, right? We all know that agents respond differently, or not at all. So, I think that that to me is no different than saying, okay, yeah, I went into Snapchat and Snapchatted the agent. God help us if we get to that point. And asked them about the compensation. It's just a way of communicating with them. So I don't think that's an issue.
I bet we need to.
But I don't think as long as you're not sending the form that way, I think that's, again, you're having a conversation with somebody. It's not really a part of the system, but
You can't upload.
no, he's not saying that. He's just saying using the conversation. Right. We said that. No,
Yeah.
no uploading documents into any systems, including showing time. All right, so this is the instruction to closing attorney. It's the same pretty much as it's always been. You see all the different sections of who pays. Just read the form. This is the one that gets messed up a lot because people don't actually read what it says. And this is part of the reason why I think it's important to check the boxes in the listing agreement the way that you check the boxes, the way that we pointed out. So you have compensation paid by the seller to the seller's broker. That's how much you're getting paid by them to do your job for them. Then you have compensation paid by the seller to the buyer's broker. That's how much they're willing to pay or contributing to pay towards the buyer's broker. So in the example earlier where Chris was talking about, well, maybe they're offering to pay some, but that person's buyer brokerage agreement is more than that. So they're going to put in their section here of what they're paid by the seller. And then down here in 4, the compensation paid by the buyer, that extra amount is going to be paid to the buyer's broker and down in this section. Okay. I would like to avoid 2, because that's us sharing commission out of our commission as opposed to the seller paying, and making that clear. I think that's part of the settlement thing is we want to be very clear about who's paying what. Now, I'm gonna 10-second convolution. The only person bringing money to the table is the buyer, because the seller is getting paid for their property. But it is reducing the seller's take home if they're paying fees and things included in the purchase price. So it's all about what angle you look at it from as to who's paying what. But the vernacular that we're currently using under the settlement is that the seller is paying or the buyer is paying. And that's going to determine what side of the settlement agreement it ends up on, right? And so that's the part that we need to pay attention to in here. The other part of this is rebates and fees. If you were paying for a home warranty or whatever, there's a section for that. Special stipulations, as always, that you can add things. And then again, just like the 258 form, this 255 form, instruction of closing attorney, is going to be signed by the buyer's broker, the seller's broker, and if the seller is paying buyer's broker compensation, the seller needs to sign this also. Okay, which is new. Instruction to closing attorney never had seller signature before, right? So that's important to pay attention to.
Well, can't that be done really at the time of the contract too?
It can be.
I mean, you send it over and it's like, this is what we expect to be paid and you put it all in there.
So that's another way to manage, right? Like
Right.
depending on what you're, and this is the part that's gonna have to play itself out, right? Is if you talk to the listing agent or as a buyer's agent, or if you're the listing agent and a buyer's agent talks to you and you say to them, hey, the seller has agreed to pay 8 bananas or whatever, right? If you have a good relationship, you have trust with that person, you don't think they're going to purposely lie to you, then you could theoretically send this over with, not as a part of, but with the purchase and sale agreement with your sections filled out for them to go ahead and sign when they sign the offer. And now you're done, right? Like this is, you're done. You don't need the pre-showing one. This is the I'm under contract one, right? And some people might be comfortable with doing that a few days later. It's all about what your trust and comfort level is with the people that you're working with, right? If we're all professionals and we're not lying to each other and we're treating each other with respect and portraying what's reality, then, you know, getting these things signed a couple of days after we go under contract or the day after we go under contract is a pretty manageable thing. During negotiation, yeah, whatever. During negotiation, you could do the same thing. You could make it part of.
It's protecting you anymore.
Correct.
They wait to the last minute, even on the way to closing to get those instructions
Right.
done.
And so
Now
you
you
should
got
do
to
these
do it.
earlier on, and that also protects you. And so that's a way to manage it as a seller. And if you're a powerful listing agent that believes that you have a good reputation, maybe that's a better path than putting the stack of pre-showing forms in the listing. But we don't know how the market's going to react to this. And so that's why we're recommending that you do the 258s, because it gives clarity to the buyers when they're seeing the house, which means they know, okay, I'm not going to have to stress about who's going to pay what because they're telling me this here, right? And so that's one of the things that's why we recommend that. But again, if you are a well-respected agent that people know, then theoretically, you know, you telling them that, you know, hey, the compensation is this, and we'll do an instruction to the closing attorney as part of the offer or at the time of offer or
Right.
whatever.
One thing, Brett, I mean, a listing agent that we know and trust, it doesn't mean that we trust or know their seller.
100%
And-
agreed.
And it may be in the listing agreement,
And they may change their mind.
but the seller may say, I'm not signing any of these subsequent
That's right.
forms, and it's not in the contract itself.
Right.
So.
And
Again,
that's what we have to play through is that especially right now, why it's such a heightened part of the headlines. We don't know what sellers are going to do, right? Sellers can change their mind. They can agree to only do this or do this or do this. And so, you know, it's always been that way, like just as a no surprise to everyone, but FMLS didn't actually protect your commission. There were no rules in FMLS about it. Georgia MLS did, but FMLS did not. And so that's one of the things that we kind of have always assumed that, oh, well, if it's the compensation's out there, it's out there, that's what it is. But it's always technically negotiable, right? Like if you don't bring somebody a full price offer, they may not offer that, right? Like they may change their mind. They may be running the numbers in their head and say, okay, well, I'll do this, but not this. It's the same thing with, when people were offering anything and everything value as part of a listing agreement. I mean, I remember a day when people would offer cars as part of, if you buy this house, you get the car that's in the garage. And that's a little insane, right? Like, but we're not in that market right now. We're in a seller's market. That was very much a buyer's market. And it was a whole different world. But that's the stuff that you never know what people are going to change their mind, right? And I think that's where Seth comes from in a position of trying to very much protect, because as he stated in the video we watched, his job is to protect us as realtors, right? Here in Georgia. And so that's the way all of these forms are slanted. They always have been, is to help protect us. You have to make the business decisions on how you operate and what you're going to do. We as a brokerage say our best practice recommendation is put a 258 form. Now, how you manage that, to Chris's point earlier, you need to manage what is the expectation from the seller. Is the seller willing to 100% say for the next 180 days, if it's a 6-month listing, I'm willing to include this, even if I have to do price reductions and whatever, I'm always going to be willing to pay the buyer's broker this. Because if the answer to that is I'm not sure, well, then we need to change the numbers until you are sure, because we don't want people signing things that they're not sure about. Okay. So that's one of the things to consider. And yeah, you might have to do a new 258 every couple weeks or every month or whatever if the seller's comfortable with. But I still think that's the best plan. I still think that's the best way to kind of circumvent the process, is make sure that that 258 matches what the seller's willing to do and the time period they're willing to do it and they're willing to commit to it. Does that make sense? All right. I think that's all the forms that we need to cover today. Like I said, we will go back to the listing agreement and go in full detail of all the words, because I think that's important. We'll go through that next week and be able to go through that in more detail. And again, I cannot stress enough, you need to ask us as your brokers questions up front, right? Don't go in and fill out forms and think, well, I think this is the way it's supposed to be. If you have any inkling at all of, I think this is the way it needs to be or whatever, then ask, right? That's what we're here for. If you happen to be with a brokerage that is not giving you that support, you should be, because that's what brokers are, that's our jobs, is to help you understand things. And sometimes it's just talking through it, right? And making sure you understand what you think you understand and verifying that it is what it is. So take a minute to look at the stuff, read through everything, and come back to us if you have questions before you go forward and get signatures. It's always better to ask the question before you get the signatures than after you get the signatures, because my favorite thing is, oh, I got the signatures, and then it's, oh, well, that's not right. You need to go back, and that doesn't make you look smart. It doesn't make you look like you know what you're doing. It always makes us look bad. So let's try not to do that.
Just
Hey, Brett.
FYI, Marcy's on
Hold on one second.
FYI, Marcy's on vacation this week.
Yeah.
Okay? So you know, we try to call, just, you know, kind of give her some time away for a little bit.
Yeah, she's on
She'll
vacation.
be back next
If you
Tuesday.
have compliance questions, just ask us. Don and I are happy to
She's already
answer them,
gone.
right?
Try to get a handle on stuff, you know, review things before she left.
Yeah.
So, you know, she should be caught up, but if you got any questions, call Brett on me.
Yep. John, did you have a question?
Right, so the next meeting is the 30th at 9:30?
Is that next Tuesday?
Yes.
Yes.
And then we have sales meeting on the 6th or 13th?
It will be the second Tuesday, whatever that is.
Okay, 13th. Thank you.
All right.
And we've got the,
And then we have the code of ethics on the 20, is it 21st? It's August. It's the third Wednesday, I think, 21st. So,
yeah, signed up about that, please do, because this is the only class we're gonna give.
and everybody's in that cycle. Remember, code of ethics is in that process. So we need to make sure that everybody's got that going.
3 hours of CE credit, free.
Yep.
And that
All
can
right.
be taken
I'm gonna
via
stop the
Zoom, correct?
recording.